Our missing children.
Also, Eric Alifo Esquire, member of the NDC communication team, is the case of the Esquires. They will all bring their legal understanding and appreciation issues we'll be talking about today. In fact, it has been a very legal week. Whole wahala from Parliament started. Every day people are bombarding us with legal. The number of people I've heard saying that now they want to go and study law. It will amaze you. Because of all these Article 97, 1G and H. That is it. This is what has brought us here. Someone will say it doesn't change the price of kinky. But it is happening.
Yes, tell me who I go.
It doesn't change the price of kinky. Kinky is still 5 cedis. Whether it is G or HU, whether it is future or is now, your portal is still there.
Go come and go kill Ghana man. You come to the ghetto, come bra.
Well, the gentlemen are seated.
I send the fake promises, so you there.
Ishak has been constant, rocking his party paraphernalia. Number one on his cape. Mr. Jantua rocking his African print as usual. And gently perusing a crucial document that he will be using for arguments this morning. Mr. Alifutu is gathering his points alongside his pink shirts. Everybody is ready. You see, they are all gentle right now. At a certain point, I will have to turn off some people's microphones. Because they say, stop interjecting me. You are interjecting me. He has taken my time. You are watching him. Or Isha could say, protect me. Ishak, I don't protect anybody. You have to protect yourself. It is possible, Anna. Is it possible? It is. Salifutu says, the victory of Mama. Yeah. Do you want to continue?
It's here now, right here.
Okay, and then you, and then you say, Ishak, you said it is possible, right?
We say it's possible, but the victory of Muhammad Tafiakwa.
I see. Mr. Jantua, can you spare us a moment?
You brought beauty to the station. Since you took your time to describe what we're all wearing. You look nice in your beautiful blouse, and your nail polish suits you.
Thank you very much.
Your hair, you've changed your hair.
Oh, Lord.
Also suits you. You're looking beautiful this morning.
Thank you very much. I appreciate it. So on that wonderful
thanks for beauty on the set.
On that wonderful note, let's begin our conversation.
My brocco.
What blocking is serious. I thought I was only one.
Oh, but I don't think on this with this set we tend to have arguments.
Oh, from time to time it will come. Isha could say I should protect him. I don't want trouble. Say protect me. That day I was so shocked.
By the way, what I'm reading has got nothing to do with the program. So
but it's part of the crucial documents we use about
it's got nothing to do.
The job is the job. All right, gentlemen. This week, another eventful week we have had, and Parliament and the judiciary, the Supreme Court threw out the Speaker of Parliament's application seeking to overturn the earlier ruling that stayed his declaration of 4 seats vacant. Many people have shared their opinions on it. Let me start with you, Ishak. Okay. You have always argued that the Speaker had no case,
yes.
In fact. So were you surprised by the outcome?
I wasn't surprised. As you rightly said, and I kept saying it. I think 2 weeks ago, a week ago, I said it. This Speaker will go down as the most lawless Speaker we've ever had. You see, the Constitution is very clear, and Ghana is operating under the supremacy of the Constitution. even if it was operating under the supremacy of Parliament, as we have it in the United Kingdom, it is not the Speaker, it is Parliament. So over there, when they say Parliament, they mean a decision made by voting through Parliament, with the Queen or the King signing. That's what they mean by supremacy of Parliament. It is not the Speaker of that Parliament. So when you come to our Constitution, where we say the supremacy of the Constitution, the Speaker's office is the creature of the Constitution. The Speaker lacks what we call, he suffered from what we call democratic deficit. He was not elected directly by the people. He was elected by the people's delegates. And what this simple means is that he draws his powers from the Constitution, and all his actions need to be in conformity with the provisions of the Constitution. Now, we disagree, and the Constitution anticipate that one day we might disagree. And the Constitution made it clear, if there's a disagreement, this is the procedure. Our disagreement stems from the fact that Article 97, we believe is ambiguous. There's a problem somewhere. And when you look at Special Tribunal ex parte Akosi, the Supreme Court had given us some guidance that anytime there is a rival meaning placed on any part of this, any of the provision of this Constitution, you will have to go for what? Interpretation. And then we also have an issue under Article 99. Some of us said that it wasn't a decision for the Speaker. It is a decision for the High Court to make as to whether there's a vacancy in Parliament or not. That provision is very clear. The Speaker have gone to assume that power. We say it is wrong. So it was right for your marking to go to the Supreme Court for the enforcement and interpretation of the Constitution under Article 130. That has made provision for that. So the Constitution have already anticipated that one day we might have this problem. Then when you come to under Article 2, there are powers or provision made over there that whenever there is a disagreement, the Supreme Court would have the right to make pronouncements or declarations. And that when such declaration is made, we must obey. It didn't say if it is made against Parliament, you need a quorum or you need enough members to make further decision. Let me take you out of our Constitution alone and go to Article 38 of the Statute of the International Court of Justice. Article 38 provided various sources of law. Among them, the third provision under Article 38 of the Statute of International Court of Justice. The court says that one of the sources of law would be general principles of law recognized by civilized nations. And what are some of the principles recognized over there? There's a principle called res judicata. Res judicata means that in every municipal level of law, there's usually a body that will have a last say. And that the court followed that particular principle. And in our Constitution, there's separation of powers. And within that separation of powers, we have given the Supreme Court the last say. And whenever they say that, you ought to obey. That is why the Article 2 is there, to say that the Supreme Court will have the last say. And said that if they made an order, you must obey it. They did not just leave it that you must obey it.
Point of order.
Yes.
Ishak, I just want to find out.
Yes.
Are you saying that the Parliament is questioning why it is?
I'll come.
Because,
Mr.
because no.
I'll answer
it's
you.
not clear to me. That's why
I'm
trying to follow you. That's
why
I'm asking you.
I'll come to that. When I get to my destination, before I realize your question might be redundant. Okay. So Article 2 did not say that, did not leave it there, that you must obey it. They proceed to say that if you are the president or the vice president that you fail to obey, you will be committing a high crime. And that will constitute grounds for your removal from the office. Only the vice president and the president would have a political penalty. The Speaker plus myself and any other citizen, the penalties are very clear. Though if you refuse to obey, you'll be committing a crime of what? High crime. And it says the penalty under clause 5. A person convicted of a high crime under clause 4 of the article shall be liable to imprisonment not exceeding 10 years without the option of a fine. And B, not to be eligible or not to be eligible for election or for appointment to any public office for 10 years.
We had the Chief Justice make reference
yes.
to that.
So what we are simply saying is that the Constitution made provision for this.
Okay.
When that particular interim order was made in the form of a stay of execution, the Speaker had no room. The Speaker was not given option. It was a clear order made by the Supreme Court. And under the principle of res judicata, he was meant to implement it straight away. For me, he should have communicated to the NDCs that there had never been a majority in Parliament. They should take their rightful position, and the NPP would take the rightful position. Parliament would then continue as normal until the substantive matter is determined. So why is the Speaker continuing to act that way? Now, I believe there's an opportunity for him. Some people say we have a constitutional crisis. We don't have a constitutional crisis.
Well, the Chief Justice
The dispute is not even between Parliament and the Chief Justice. The dispute is between the Supreme Court and that of the Speaker, not Parliament. This Speaker is acting as a Speaker, not Parliament. When we say Parliament, we meant a decision voted upon by members of Parliament. Okay. It wasn't a decision voted upon by members of Parliament. It was a decision made by the Speaker.
Okay.
Some people say he had merely given information. He did not give information. Look at the effect of it. Right. The effect of it is effectively vacating 4 members of Parliament from Parliament. Okay. Who they even have legitimacy to be in Parliament than the Speaker.
All right.
The Constitution is very clear. Power is drawn from the people.
Yes, and you've consistently made this argument.
Yes.
Now, one of the criticism of the Supreme Court's ruling,
yes,
has been that it's not consistent with the past principles. As old as 40 years. Now, people cite very simple ones, not going into the details of the legalese issues. People cite the incident of Starr, for instance.
Yes.
The Supreme Court speaks passionately about denying people representation.
Yes.
And remember that at the time the Speaker made the declaration, we're under 100 days to the elections, right?
Yes.
Yet again, the Supreme Court, as some have suggested, point to the Starr case and say that it looked on for people to be denied representation for a whole 4 years. They point to the Jache Kwesen situation as well. That how is it that in this particular case is under 100 days to the elections, the Supreme Court is speaking passionately about denying people representation. Is it that some people are more human than others? And you have just about 3 minutes to answer because I've given you plenty time to speak.
You see, when you are discussing with people who do political law, it's very difficult to discern through. They are doing political law. Let me explain why this definition might be different. Look, in every jurisdiction, the court systems are passive. Do you understand that? Courts are not placed going knocking every door, is crime being committed. No. Courts are passive. It's not just Ghana. Every jurisdiction. You have to knock their door before they act.
But their doors were knocked.
No, I will tell you how different doors can be knocked. So if, for example, I don't have 3 minutes. I don't have more than 3 minutes. I would have given you an analogy.
Okay.
As to why some situations they might act, some situations they are slower to act, of which I will explain. So this particular one, are you saying that what they have done is outside the law? The answer is no. For example, people said, why would they give an ex parte application? Why would they grant it? And you ask, why not? It might not be the everyday thing to do, but it's not just in Ghana. Elsewhere, they give ex parte application based on the circumstances. For example, in Britain, for example, as part of the common law, even a celebrity having an affair can go for an ex parte to prevent a journalist from what? Publishing a story. If you believe that the whole purpose, the exigency of the situation require an ex parte application, it can be given to you. Or if giving notice to the other side would defeat the whole purpose of what? Coming to court. So this is not outside the law. It is part of the law.
Okay.
And the Supreme Court always have residual powers
Okay.
to implement the law.
All right.
For what they call it, the Kwesi particular case, for example.
Your 3 minutes is up.
Okay.
Okay.
I'll-
So let me just before I go to Mr. Alifo, I'll just read some of the criticism that has come. I mean, I mentioned some, but I'm going to read the rest
Okay.
here. When the others are done, maybe you can quickly have a bite at some of the
bite
other.
at them.
Yeah. So
Yes.
this one is by Kweku Azar. He wrote this on his Facebook wall yesterday. He says, politicians can champion a position in the morning
Yes.
and oppose it by evening.
Yes.
But courts cannot afford such inconsistency.
Yes.
Their very survival depends on stability and adherence to principle. Courts derive their legitimacy from the steadfast, even-handed application of the law. The moment they falter, interpreting the same facts to support jurisdiction in one case, but deny it in another, they chip away at public trust. Courts cannot extol the right to fair hearing, only to decide some cases in ex parte hearings. Courts can't resolve some disputes in a matter of hours, while others, equally significant, languish for years. Courts can't enjoin an MP from serving his constituents for 15 months, while underscoring the sanctity of representation in other cases. People can accept decisions they disagree with, as long as those decisions are consistent. What citizens resist is what they perceive as Anansi justice for some and Intikuma justice for others. Such disparities breed suspicion and resentment. When courts fail to apply principles evenly, the public tunes out, disregarding rulings that may, in truth, contain sound reasoning. Consistency isn't just an ideal, it's the foundation of judicial legitimacy. When courts become inconsistent, they cease to be guardians of justice and start resembling politicians. Many of us have already tuned out our politicians. Sadly, too many of us are also beginning to tune out the courts as well. Whither are we drifting when even the courts that are supposed to be the last bastion of fairness and reason begin to lose our trusts? So that's one of the major criticism that has come in.
Yes.
So would come back to that. Mr. Alifo.
Yes, good morning to
Good morning.
your listeners. I don't know what question you put to me, but
I mean, to the very same question,
yes,
your reaction to the Supreme Court.
well, I think that the Supreme Court is interfering with the work of Parliament, which is not good enough. It's meddling with the affairs of the proceedings of Parliament, and I can see that my friend is struggling very much to justify everything that is coming from the court. You see, that's very unfortunate. I can see him arguing that as long as there's room for the court to behave in a particular manner, they can always do so. It doesn't matter. But it matters. That is why it was just appropriate and timely that you read Kwakwazan's post on consistency to him. That, you see, for lawyers, we expect some amount of consistency by the courts. That is what guides us. That is what helps us to prepare our cases and go to court, because we know that there are settled rules and laws that we know that the courts will have to follow, principles that the courts will have to follow. And so we make our arguments and we prepare our briefs on the basis of those, and we send to court. And the court can always say that because I have room to change whatever I want to change, I can change it anyhow. Then it becomes a problem. When Ishak started, he talked about, he lambasted the speaker very much. And then he talked about there's a supremacy of the Constitution. You see, the supremacy of the Constitution is not the supremacy of the courts, of the judiciary. supremacy of the constitution doesn't mean supremacy of the judiciary. It doesn't mean so at all. The judiciary has a role to play in interpreting the constitution, and when people are aggrieved by the implementation of the constitution and they go to the Supreme Court, then it does justice. They go to the courts, it does justice to them. That's what the judiciary does. The judiciary is not supposed to meddle in the affairs of the co-equal arms of government. So when he's talking about supremacy of the constitution, we all understand that. We all agree to that. All of our institutions draw their powers and their authorities from the constitution. The judiciary does, the executive does, and then the legislature also does. And these people have roles to play. When they are playing their roles, you see, you recall that. And again, he talked a little bit about the British Parliament and was citing the Queen and all of that. It is not the same thing we are practicing over here. The government, the whole government is in Parliament. The Prime Minister is in Parliament. So that's a parliamentary democracy that they are practicing over there, which is different from the executive type of democracy where there are separate arms, completely separate arms of government that we have over here. Now, you would recall that even before the Speaker will act in this particular matter, Mr. Fenyumakin had run to the court, even before the Speaker will act, saying that don't even let the Speaker act at all. And so when my friend is saying that when there are rival interpretations of the Constitution, you have to run to the Supreme Court, doesn't mean that people are going to create rival interpretation of every provision of the Constitution every time. No.
But the Chief Justice in their ruling did say that at the time the Speaker was giving the ruling, it was clear that there were differing opinions with regard to what it meant.
There may
and
be.
So
yes.
He was on notice. Yet went ahead to go and
yes, he has a
ruling.
role. No, the Speaker has a role to play in Parliament. That's exactly what I'm saying. You see. Let me tell you something. You see, they create this impression in our minds that the Constitution can only be interpreted by the Supreme Court. It is not true. You see, in fact, when the President is appointing ministers and is appointing more ministers from Parliament than outside of Parliament, he is implementing a constitutional provision. He wouldn't run to court first and go and say, explain that provision to me, which says that I should appoint more ministers from Parliament than from outside of Parliament. He's implementing the Constitution. We are always implementing the Constitution. Everybody.
But then,
don't.
I'm not correcting you.
No.
I'm just adding something. We say 4 occasions. I quoted ex parte acosa.
No.
That's what applies here.
No. What does it say? What does that case say? But I don't want him to. So what I'm saying is that the Speaker has the right to act in Parliament. Do you understand? And if he acts and anybody is aggrieved, that person can go to court. Nobody is saying, but even before the Speaker will act, that's what I'm saying, even before the Speaker will act, Mr. Fenyumakin ran to the court and said, stop the Speaker from acting. Don't let him even act at all. Don't let him even, because that constitution, we disagree with you. So does that mean that every time, that's what I'm giving you an example, if as soon as they elect a president, and before he will appoint a minister, I will run to court and say that I suspect that the president is going to appoint more ministers from outside of Parliament than Parliament, so interpret that constitution. No, that provision. So they allow the president to, because the Speaker is interpreting the constitution every day. Or let me not say interpreting, it's implementing the constitution every day in Parliament, just like the courts are also doing, interpreting the constitution. We are also doing it even in our everyday life. We are always, and the executive is doing that every time. It is only when somebody is aggrieved that the person goes to court and says that no, the implementation of this particular provision of the Constitution is inconsistent with what the Constitution means. And so there's controversy. But if you are going to give room to people to say that, well, once this is implemented, it's going to affect me somehow, so let me run to court and say that, oh, I disagree. And then people will say, oh, there are rival opinions, there are separate opinions, there are different opinions, so the Supreme Court has to come in. I don't think that is the essence of this whole idea that the Supreme Court. But let me quickly say a few things that he also said. Okay. So he said you see, the reason why, for me, I think that the Supreme Court shouldn't have even touched that matter at all is that there's something called a political question. I always hear that. The last time I heard Attorney General said that, oh, well, there's a case in Ghana which says that the political question doesn't. There's nothing like that. You see, the thing is that we are not prepared over here. We are not in the mood to advance proper democracy in this country because the issue of political question is a common law. It's an intelligent, common sense principle established by judges when matters come to them. They look at it and say, yeah, this democracy we are practicing. If every time we are going to go to Congress and go and stop them from doing things, it is not right. And so let's come out with this and say that, well, this one, as long as it's purely a political matter, we can't touch it because they have the right to do it. And so how would somebody say that it doesn't apply over here? It is only because we don't have judges who are willing to advance our democracy. Again, the last time, you see, if you recall, I argue here that when they were trying to let us say that this democracy have people, they destroyed this, they did it. And I'm saying that, look, those people were not just common criminals. And so we have to accord them. In fact, we have to make provision for the fact that they may go wayward a little bit. And they have to caution them and discharge them. They want us to go strictly by, oh, this is how it is done. But in countries where they want to advance democracy, promote democracy, they understand how to, and these principles, they come out of case law. Case law, mistrial, for instance, when the last time when the Attorney General was bastardizing a party in a case and telling the party to come and implicate another person, blah, blah, blah. And then when the counsel for the person that they were trying to implicate applied for mistrial, they saw mistrial is not known. Those things are just common law principles. The judge will sit down and say, yeah, indeed, the way this thing happened, I don't think that we should entertain this. So mistrial, finish. And then they will come out and tell us that it's not known here. Why would a political... And let me tell you why I think that this is a purely political matter. You see, when the Speaker made the declaration, the 4 affected MPs didn't complain. They didn't go to any court to say that their rights were infringed. Nobody from any of those 4 constituencies had complained. None of them has instituted any action. It is a party. It is MPP that says that this action has affected our status, and now we are changing from majority to minority, and so Supreme Court help us so that our majority status will be restored. That is a matter for Parliament to deal with.
But you see, the Chief Justice, you know, the issue of politics, when the lawyer for the Speaker, Thaddeus Story, made the argument, for instance, for Justice Gaiwu to recuse himself or to be let off the panel because he once stood on the ticket of the NPP.
Yeah.
The Chief Justice cited in other instances where there's a former PNC General Secretary, Justice Puaman, and another who from the NDC as well.
Yeah.
But then the fundamental point she makes is that this is not a political issue.
It's a political issue.
It is a constitutional matter.
Let me explain this to you. I don't want to wade into whether a particular justice... Yes, I don't want to wade into whether a particular justice should have recused himself or should be kicked out of the panel or not. Okay. I don't want to go into that. But if Chief Justice is saying that this is not a political matter, it's wrong. It's a purely political matter. And I even heard lawyer people who also agreed to that. And I just explained to you, I am saying that nobody has gone to call for a human rights issue in this matter. Nobody has. In fact, the 4 MPs that were affected did not go and say that their right to natural justice were infringed, and so they have come to court for redress. Nobody. The only person that has gone to court is the minority, the non-minority leader, the former majority leader. He is the one that went to court and said that, look, if this declaration by the Speaker stands, our majority caucus will now become minority caucus, and so Supreme Court help us so that we are reinstated as a majority. It's a political matter, purely political matter, and it isn't like we haven't seen this before. Even in U.S., as we speak right now in U.S., the Congress is controlled by Republicans, while Democrats are in the executive, in the White House. So it can happen right here also. You see, and I am saying that, look, all that is happening is a consequence of the fact that they stole the election in 2020. They stole the election. They had to kill 8 people in order to have the same number of MPs as NDC. Otherwise, Ghanaians have never voted like that before. Anytime they elect a president, that president will have an absolute majority in parliament. It is only this parliament, because they stole the elections, they killed 8 people in order to steal some of the seats to have the same equal number. No. And they are now having the consequences of that. And now they are running to court for the court to help them.
When you say that the elections were stolen,
yes,
you had the opportunity to go.
It doesn't matter. Look, those things. It doesn't matter. I am saying that, look, we are struggling in the courts. Everybody can see that we are. Look, this Supreme Court, this current ruling, and people criticizing the courts that there are similar cases that they are not paying attention to. Why do you think that the election petition we cannot go to court and still suffer the same fate? So don't think that anytime we go to court, there's justice coming from the court. So I don't believe that. So I am saying that everybody knows that they stole the elections. They killed 8 people. Didn't they kill 8 people? How did they kill those people? Was it not in the declaration of parliamentary seats that people were killed? So they stole the election. The fact that we didn't get justice in court, or perhaps we didn't get the wrapping sheets or whatever, doesn't change the fact That they stole the election. Ghanaians had never voted like that before. When did Ghanaians vote and give a president, a different president and a different parliament, or parliament will have equal number of? We all know that they stole the seats. We all know. He also know. MPP people, they also know. You do. The fact that you say you don't doesn't change anything. We all know. So I am saying that, look, these are the things. Don't think that anytime people go to court, they get justice. You understand? Whether we are forced to accept it
but I mean,
or not,
you had the opportunity to.
it doesn't matter.
Case,
it doesn't matter. People appeal. People appeal. Look, do you know that?
To flatly say the elections were stolen.
Do you know that? In the last election petition?
Because you had a chance. Yes.
Do you know that in the last election petition, every single application that Chachu Chikata did, he lost it to the review level. No single person dissented in any of those. No single person, no single judge. I am saying that these things are not real. They have happened, but they are not real. You see, people haven't you also seen that even the Afrobarometer talks about how confidence is eroding in the judiciary? Or you haven't seen that too?
I've seen that.
Yes. So I'm telling that these are real issues. The judiciary needs to sit up.
All right.
And so for them, they can run to us and come and tell us that, once the court has ruled like this, and that's why every time they say run to court, go to court. Everything they say go to court. Because they know that when you go to court, it will come their way. Okay. And again, the last point I will make before, you see,
your 3 minutes is long.
Yeah, well, let me just say one last thing, because I wrote something yesterday.
Okay.
And I said that if I were the Speaker of Parliament, I would defy the Supreme Court. You see, right now, he's telling us the consequences. I know that there are consequences for disobeying the courts. Do you understand? Yes. Now, I'm not saying I do not know that at all. I will be ready. I'll be ready if I were the Speaker. And I'm saying this. I'll be ready to defy the orders to assert the independence of Parliament and for them to send me to jail.
But that
would be history. That would change the course of our democracy forever.
This is coming at a time where many people are admonishing the Speaker to just adhere to the ruling for peace to prevail.
And I said that I will not side with those people, because some of those same people also saw that there was injustice. They have cases in the court. They are not treating them well. Ishak is saying that, the courts can treat some of the cases differently. Well, Ishak is saying that, the courts can treat some of the cases differently. They can treat the Starr differently because there are situations like that. So what kind of justice is that? So you treat so the court look, those cases were also prosecuted.
The courts are passing.
Those cases were the host reminded you that people went to court for those cases as well, and the way the court's attitude was different from this attitude in this one. And you think that is not a cause for worry for us?
All right,
it is. So if I were the Speaker, I would not obey and they should send me to jail. And it will make history. In fact, I would like the headline to say that because the Speaker is trying to assert the independence of Parliament, he's sent to jail. It doesn't matter. I'm telling you, if it were me,
all right,
I would go.
Mr. Ali, thank you very much for your submissions. Let me now go to Mr. Kwame Jantua. Mr. Jantua, the Supreme Court at the end of the day said the Speaker's application was without merit, and so it was effectively dismissed. All the counts on which he came on, all the grounds on which his lawyers came to court on were all, in essence, rubbished, really.
Quashed.
Quashed, yes,
Legal
the right word.
Language.
Yeah.
So your question is?
My question is, what is your reaction? Many people have given theirs. We've heard from the NPP's representative here. We've heard from the NDCs as well. The NDC says that the fact that it's coming from the court does not make it just. The NPP rep says that it was right in order. What does your understanding of what transpired also say?
Good morning to our listeners and our viewers. But my brother, would the Speaker be able to stand prison with his age? I doubt it. Maybe if he were younger. Maybe if he were younger. Look. I believe the Supreme Court has a duty and a role in interpreting the law, but also in having foresight of possible challenges of an ex parte case brought to it. I would have thought, taking into consideration the magnitude of Parliament being one of the arms of government, and the fact that Afenyo Markin, when he took the ex-party to the Supreme Court, the action he was looking to quash hadn't even taken place. I would have thought the Supreme Court would advise him that go and inform the other side of what you're trying to do.
Well, the Supreme Court said they went ahead to hear the ex-party because the Speaker was on notice. And they made reference to the Hansard of Parliament, where the attention of the Speaker was drawn to the suit, and the Speaker said there had been an agreement to serve them. There had been
saying before
hearing the ex-party.
Before hearing the ex-party.
Yes, and I'm telling you that this is I'm explaining that this is a justification the Supreme Court gave for hearing it ex-party, that they in their view the Speaker had gotten enough notice.
And the Speaker and the Speaker is saying he didn't get notice because of the time it was brought.
But also, let me even, the Speaker hadn't even acted at the time. So they said he shouldn't act at all. He shouldn't perform his duties. Yes.
And for me,
So
that is the crux. He
doesn't make sense.
acted. It hadn't happened.
Yeah, and then the court again says it didn't have to happen if there was a visible threat of it happening. And they said that they decided this did say that there have been numerous instances where they have had such applications.
Okay. Wait.
Please, you've had your turn.
So if so, can a person's conduct, which was used in Honorable Michael Kwe's case, and a person's action, which was used in Babin's case, evict them from Parliament? Can that not be? Can that not be? Because what did Michael Kwe say? Michael Kwe said, the person's conduct has shown. And Babin also said, the person's action has shown. Really, I would have liked a situation where this kind of controversy will not come up. But the Supreme Court would act in a way that brings consensus. Because at the present moment, tell me, is there consensus?
No, there isn't.
And what does it look like?
A standoff.
Apart from a standoff, what does it look like?
A crisis?
Me, I have my power in my house.
Yes.
You have your power in your house. You can't come and interfere in my house.
Yeah.
So you've thrown a bomb in my house. Okay, I will show you. I will not act on it. When the verdict of the Supreme Court went to Parliament, what did the Speaker do?
The Speaker adjourned indefinitely.
Simple. Has he acted on it? No. Is that what we...
It's not unlawful.
It's not unlawful.
No, it's not.
How can it be unlawful? How can it be unlawful? 110, what does it say? Article 110. What does it say? Let me read 110 for you. 110. 110 says, subject to the provisions of this Constitution, Parliament may, by standing orders, regulate its own procedure.
Absolutely.
They are not above the Constitution, but they have their standing orders. They have their standing orders. And if the Speaker does not want to go according to the dictates of Parliament, you adjourn. Has he not adjourned?
He has.
The one thing now, which I found significant, and as I said on another channel, I respect the CJ very much. But I think the CJ exposed herself during her interaction with Hadia Sorry when she commented
that we are in a constitutional crisis.
That what is this? What country is this that Parliament is not opening? That is
I have the sound here.
That is your personal opinion that shouldn't have been said there. Because as the Supreme Court, you do not have control over Parliament. And Parliament is what? It acts on its own rules and regulations, being governed by the Constitution, being governed by their standing order. I would have liked a situation where she wouldn't have even made that comment.
Let's hear that particular comment in question that you made reference to.
It is important, and the question of whether the jurisdiction has been properly invoked is different from whether the jurisdiction exists. It's a different legal question. It is important to place on record that both the plaintiff and the Attorney General have complied with these orders, and this court is able to complete hearing of this suit if the Speaker chooses to file no process.
So that's the wrong sound I played, but I'll get that for you.
It was the Speaker's lawyer who reminded her that, dear Speaker, this is not on the table for us to discuss. It's not part and parcel of it. And she agreed. I didn't think she should have given that outburst. In terms of interpretation, Appeal Court can interpret. High Court can interpret. Parliament can interpret. Even the Council of State can interpret. But the Supreme Court, to my understanding, and maybe my understanding is wrong, the Supreme Court has the power to interpret where there is confusion with interpretations from any of these bodies. Mm-hmm. And they have the overall power to interpret. Does the Supreme Court, you might say they do, in terms of staying Parliament's action? You might say they do have that power. But I believe that we need a situation where there is harmony. The Supreme Court being a court of power, there should be harmony, and the direction should be such that it opens up for discussion. Because, you know, Ghana, everybody will feel me a jack. Everybody will feel me a jack.
True.
Where you have a president who a bill is brought to you from Parliament, and the bill, you have regulations as to how you have to handle the bill. If you don't agree to assent to that bill, it is you rather send it back. Please.
His microphone.
Please, when you were talking, I was quiet. Guys, you.
Please allow him to make his point, please.
There is a rule. There are rules and regulations as to what, as a president, you need to do when you do not agree to a bill that has come from Parliament that you don't want to assent to it, irrespective of whether there's a case in courts or not. Yours is to send it back and give reasons why you would not assent to it. Pronto. Let the court take its what you call it. You can even use that to buy time. Yes, the Parliament can, by so doing, by 2/3 majority, decide to overrule the president and pass the bill. Yes, that is there. But if your reasons are cogent and strong, Parliament will have to relook at the bill they brought to you. So if you now go to and say you're waiting for the courts to make a decision, you then make it possible for the courts to be able to do what they feel they would like to do. And I remember someone quoting. I'm trying to find.
Okay.
Someone quoting. What's the guy's name? Yes. Someone quoting Montesquieu's principle of what? Separation of powers. Strict. If you look at it, it seems to be strict. I don't think in our jurisdiction we run a strict form of separation of powers. That's why there should be chance to see how in certain areas, in certain cases, we can sit together and judge and solve situations. Because the standoff is neither here nor there. It doesn't help anybody. Anyway, when you look at the reasons why this particular issue came up, would it have been possible to hold a by-election considering the time it is left?
No, it's not.
It wouldn't. Again, I was expecting the Supreme Court, and you might probably tell me that it wasn't in line with what they were discussing, but the Speaker referred to some of the issues he looked at in arriving at his decision. Mm-hmm. I would have thought the Supreme Court, because there's public interest in there, would clarify Mike Okwe's decision. Would clarify Adjoa Safo's stay.
But that would be for the substantive case, which they are going to hear on November 11.
Well, you think they will clarify? They should have done it now to take it out of the way. That it cannot be used as a reference because of A, B, C, D, E. Yes, can be used as a reference because of A, B, C, D, so that the public can understand the references made to it. I bet your bottom dollar. It would not be referred to in the substantive. Hearing. I don't think so. I think this would have been the right time for that to be done.
So you think? I've heard many people, for instance, admonishing the Speaker to abide or to comply with the ruling, and others, and asking that we need to protect the democracy and all. What do you say to those who say that? Why didn't people make such overtures equally or appeals to the judiciary as well in the lead up to this particular hearing, that cool heads need to prevail? Why are they admonishing the Speaker and are not saying same to the judiciary? Those who say that.
In similar situations, the judiciary was quiet. So, one of the reasons that the Chief Justice gave for the
SAL one?
No.
Okay.
One of the reasons they gave here, was
to deny them the people representation.
Yeah, was the how did they call it in law? Or the ultram petum, that you didn't give the
fair
other
hearing.
side a fair hearing. What would have been the fair hearing here? By their action, hadn't they abdicated their seat?
No, you call them and listen to them.
Listen to who? Your action has shown you, your conduct. Your conduct has shown you. So you come and describe your conduct to me. Is that what you're telling me?
Yeah.
Is that what you're telling me? I'll call you. Your action. My baby adiano. You seen that I stolen this straw.
But Ishak, you know that there are exceptions to the rule when your conduct clearly shows that this is what you're doing.
Your conduct shows it.
It doesn't require you being called.
It doesn't.
It is not true. It is not true. There are exceptions to it.
It doesn't. So,
but it's not true.
So, you see, there are quite a number of things that the Supreme Court could have done and said to clarify a lot of these things. The other question of whether it is political or not, go to 97. Go to 97. Go to 97. Go to 97. H and is it H and J?
97 1 G and H.
Yes, 97 1 G and H. Let's even take H. If he was elected a member of parliament as an independent candidate and joins the political party, who are they talking about? What are they talking about?
Independent candidate.
Are they talking about a lawyer? Are they talking about a doctor? Are they talking about a nurse? Are they talking about a sweeper, a road sweeper? The person they are talking about there, what is he?
He's a member of parliament, a politician.
He's a politician. He's a politician, black and white. His profession even doesn't come in there. He's a politician. So the Constitution looks at constitutional issues, looks at political issues, looks at social issues, looks at international issues. Read through the Constitution. If these headings I've talked about, you don't find articles in the Constitution that covers it. And this has got to do with NDC MPP as to who is majority or minority. Political again. So when the Chief Justice says it's not a political issue, it's a constitutional issue, it is commingled in both.
Okay.
Trying to interpret a political issue constitutionally. Commingled.
All right. Thank you very much. You said you want to quickly
Yes,
respond to
yes.
it. So you do that in 2 minutes, then we can do the
Let me
questions
clarify,
element.
Let me clarify some of the arguments of my good friend here.
2 minutes.
Yes, Mr. Alifo. So Mr. Alifo mentioned that every day they interpret the Constitution. So what are we talking about? It's not only the Supreme Court. That's not what we are saying. It's misleading to say that. What we are saying is that if there is a disagreement, ex parte Acosta says we must go to the Supreme Court for interpretation. And there are 4 situations. So we are not saying everyday interpretation. We say when there is a disagreement, and one of the situations they gave was that when there is a rival meaning to it.
Okay.
And another way I want to say it, it's really a disappointment. When I listened to the Chief Justice, she expressed some frustrations and concerns. And I shared those concerns with her.
About?
When I was trained in the English system, they have a judicial courtesy, and we borrowed it from them. There's a reason why we do it. In court, when a judge is about to speak, you as a lawyer need to be quiet and sit down. It's not only the judge. When you are colleague, no, the Chief Justice expressed it. That
Which
frustration.
one?
It's
Is it
like, let me come. It does.
But what
it
has that
does.
got to do with this?
It's a way of transporting the disagreement.
Are you talking about the point
It's
where she talked about the crisis?
how the whole system is polluting and undermining the system. I mean, Kwekwe Azar was talking about those. I'm going to connect it to the Kwekwe Azar situation.
Your 2
How
minutes is
the
almost up.
judicial system can be undermined.
Okay.
I agree with Kwekwe Azar that there is a need for some level of consistency in law. If you look at Fuller law of inner morality, consistency helped in instilling some legal principles.
Okay.
Nevertheless, Jeremy Bentham, again, another philosopher, condemns some consistency in the common law. That's why he called it Dock's law. But if you look at but what the Supreme Court is doing is not strange. Look at Article 129, Clause 3. The Constitution is very clear. The Supreme Court may, while treating its own previous decision as normally binding, depart from a previous decision when it appears right to do so.
Okay.
And all other courts shall be bound to follow suit.
All right. And
So if it is right to do so, you can depart.
All right, that's
so
okay.
I'm not sure whether Kwekwe Azar, I don't agree with him fully.
Okay, that's fine.
Yes.
You two, you also have 2 minutes.
Well, I don't know if I should. But you see, all that you are saying, you are just telling us what we know already. The Supreme Court may depart. But we are saying that if they are departing in situations that create suspicion, because everybody is looking at, there are several cases before them.
But not everybody will agree with the Supreme Court.
No, that's what I'm saying. As for that one, yeah, we all know. But I'm saying that consistency, you see, because the law is there and they are supposed to help. Now they are confusing lawyers. You see, for instance, we all know, and it's a settled practice, that when you go to court with ex parte, because they are not hearing the other side, the order is only for 10 days. And then the 10 days, they expect that the other party will also come quickly so that you hear the other party's argument. Look, and then we have been following this for years, donkey years, and then all of a sudden, in a particular case, political case, then even the applicants ask for 10 days, and you give them more than 10 days. You say that, no, for us, your 10 days, we are ignoring it because we think that it would be better to give you up to the time the case ended. And you are saying that because they have a room to do that, they can do it.
The CJ says,
yes,
if the parties had all complied and filed their responses, it would have been well within the 10 days.
It doesn't matter. The thing is that he's giving more than 10 days, which the applicants have asked. Look, don't always be. The CJ is not explaining these things very well. The applicants have asked for 10 days. You give them 10 days or less. You don't. Instead of doing justice, and in other cases, that one you wouldn't know that. So I'm saying that is where the consistency comes in. Okay. You understand? The consistency is to guide us. so that when we are going to court, we know what to expect.
All right. Okay. Thank you all very much in relation to this issue. So we just have a quick bite on the battle of questions between the two parties. I'll start with who do I start with? I started with you first, right? Yeah. So let me start with Mr. Alifu at this point in time. The NDC flag bearer, John Mahama, posed 5 questions to the NPP's flag bearer, Dr. Mahmoud Bawumia. He responded with 50 questions and says that if John Mahama wants any answers, he should man up and debate him.
Thank you.
And not be putting up flimsy questions. Why can't John Mahama simply just debate Dr. Mahmoud Bawumia and settle this issue?
Well, it's not ready to debate.
Instead of posing questions in the air.
It's not ready to debate. Look, and we have precedent also. When was it in 2020? No, in 2016 elections, when Dr. Bawumia said John Mahama should go to Abosoka and go and debate with the scrap dealers and spare part dealers. He should go to the market and debate. He should go to the necessary training and all of that. So what has changed? So he's also not prepared to debate him. That's all. As for the throwing out the questions, it's politicking. I don't. If any of them is minded, they should come and answer the questions for each other. But other than that, I don't think this is a big issue for me. Okay. But nobody can force John Mahama to go and debate Bawumia, because it happened before. When you told him that you will not debate him, he shouldn't debate. Nana Akufo-Addo should not even debate him. He should go and debate with also Bawumia should also go to the spare part dealers and go to the necessary training and whatever to go and debate. That's all. Right. It's close. For me, I don't think that I have to waste my time on this one.
In fact, your T-shirt has Bawumia on it.
The attitude.
Why couldn't
the attitude of
my question? Wait for my question. So, I mean, simple five questions.
Okay.
Why couldn't the vice president just answer? What was the 50 questions about?
You see, the attitude of the NDC flag bearer is really disappointing. First, you score the point that Bawumia is not your equal, and therefore you will not lower yourself to debate with the vice president. But you find it the need to ask him questions. Can you see the hypocritical? And I remember last week I said something here. It wasn't an insult, but you asked me to withdraw it. His behavior was what made me to question whether the John Mahama was actually a man or a mouse. But in the English system, a mouse is not an insult. It means he is scared.
You see,
I withdraw it. But then his behavior.
Because the point is
his behavior.
Ishak.
Yes.
Ishak, here's the thing.
No,
I get
in
it.
English, when we use that, we say, why is he so scared of Bawumia?
Let me make my point. Let me make my point.
Okay.
So here's the thing.
Be a gentleman.
Context is everything.
Okay.
And worldviews and societies also matter.
Okay.
It may not be anything to say.
No, it's not.
A mouse in the UK, but you may say it here and it will be taken out of.
No, what I'm simple
just like how raising your left hand in class in Ghana is more like a forbidden thing to do, but in the UK you can easily raise your hand. So that you just have to appreciate the context.
I accept that. But am I right to say why is he so scared of Bawumia?
You can say
it's like he's hiding and throw 5 questions and hide again. Come out and debate with the guy.
Okay.
I am a messenger for Bawumia. Mr. Alifo is a message for John Mahama. We cannot deliver it better than the two of them. Okay. That the Gomez have a saying that a whistle is best blown by the owner. And this is the reason why Bawumia wasn't in the ballot. Bawumia is now in the ballot. And said that, come out, we debate.
But
he will hide somewhere in there.
What would you say to those who say that?
He will hide somewhere in Shabova and throw 5 questions away. But Bawumia wasn't in the ballot.
So what would you say to those who say that? What would you say to those?
But they can't even hear me.
What would you say to those who say that? Why are you so desperate for a debate?
He is desperate for a debate with John Mahama because Bawumia believed he was incompetent president, and he's still incompetent in opposition.
All right, thank you.
We want him to show his incompetence to the Ghanaian people.
All right, thank you.
He is scared of showing it.
All right, thank you. Mr. Jantua, the battle of questions, does it serve in anybody's interest, the electorate? Does it go to the core of what people will be basing their ballots on December 7th?
The MPP should stop using this incompetence.
It is.
They should. They should.
Why?
Because their own rule has proven to them that they've also been incompetent. It has proven to them, proven to Ghanaians that they've also been incompetent. You came and you took over an economy where you said there was no money in the coffers. It was dry bones. They are eating it to the last bone. You are leaving. Are there not dry bones? Are there not dry bones?
They took over when we were at the IMF. They are leaving
back to IMF at a higher debt level, 760 something billion. So what are we talking about? Look, now they should stop this infantile politics that they are playing. They should stop it. I want to answer your question. Come and debate me. I have my football. You're not letting me dribble some, so I'm taking my ball. They should stop it.
The two parties?
They should speak to the Ghanaian.
By debating.
If it doesn't need to be debated. Brother Mahama has asked questions. Prove him wrong. Answer it. Throw some at him. Let him also answer it.
We've done that?
You didn't answer.
Are we? Is it not campaign period?
It is.
Is it not campaign period?
It is.
Is it true that our economy today is junk? Is it true? Is it true that today we have gone into people's private monies? Is it true or is it false? Is it true? Is it true that today cocoa has reduced by half in terms of production? Is it true or is it false? Is it true that between these last 8 years, exploration to production, we haven't done any? Is it true or is it false? Is it true that in this era, galamsey on water bodies increased? Is it true or is it false? And then you have a vice president who says, what has happened in the past? Did Akufo-Addo not come and tell us that the Mohammed's administration, they are incompetent? Look at what they've done. Yet did he not say it? Let me show you that I can do it right. What has happened? Wait, isn't Bawumia repeating the same thing Akufo-Addo told us? And if he's repeating the same thing, how can we trust that the right things will be done? How could we trust? Another thing, and this goes for the two parties. Ishak, where's your constitution? Or where's your manifesto?
My Bible?
Yes, bring it. Bring it. Just bring it.
We are wrapping up in 2 minutes, please.
Just bring
it.
Have you seen this big book?
Yes.
What does it have in it?
Their manifesto.
All the things that they want to do.
Yes.
Have they costed it?
No.
Do we know how much it's going to cost us?
No. On both sides.
On both sides. Have they answered that question? Especially now when we are in financial crisis, when we can't even raise $3 billion, we've got to go to IMF. How much is it going to cost us?
Yeah.
Are there not projects that have been stalled? So in times of crisis, do we not claw back and say, it hasn't come out. Look, our manifesto hasn't come out.
In a minute.
And if our manifesto, listen, our manifesto hasn't come out. The CPP's manifesto isn't out. But if it comes out, and for me, if there are things in it that aren't right, I will talk about it. Because you see, we are not building a political party.
We are building a nation.
We are building a nation.
All right. Okay. Thank you very much, gentlemen, for joining me for the weekly review segment. Ishak, I got a message from one of your colleagues. Your colleague, he said that you should cool down.
I should cool down.
Now, for me, it's not party manifestos that will move this country. A national development plan where we all decide to be part and parcel of. It's not here. I've told you it hasn't come. All
right. Thank you very much, gentlemen, for joining me in the studio. So, Ishak, I mentioned to you that one of your colleagues said you should cool down. So,
at long last, the battle.
I told you people that were Wahala Day. You people didn't believe me. When I said it, Mr. Johnson, I said, oh, they are very calm. I said, you.
Very good bad boy.